Hey, realtors, are you worried about lengthy court confirmation hearings that slow your probate sales down? Well, what if there was a way around it? I'm Keith Moten, your legal ace in the digital space, giving you inside probate tips from an experienced probate attorney on how to avoid court confirmation sales. Okay, so whenever you file a petition for probate, there's a bond requirement. On the petition for probate, it's going to say there's an option to decline a bond. 99.9% of the time, the court will not allow someone to serve without a bond, mainly because the bond is an insurance policy that protects the beneficiaries of the estate in the event that the executor or administrator decides to run off with all the assets and or money of the estate. So there's always going to be a bond requirement. However, in that bond, there's two types of bonds that your client can get. They can get a limited bond, which is the cheapest, or they can get a full bond. I'll explain the difference. Now, a limited bond is cheaper, and probably 90% of people get the limited bond because it's cheaper and it's affordable. I want to say it's only a $200 premium in California, but there's a catch. If you have limited authority, that means that you have no authority to take any actions without court authorization. So what does that mean? That means that if you sell the property, you're going to have a court confirmation. At that court confirmation, your sale could be overbid or not approved by the court if the formalities aren't met in that hearing. On the other hand, full authority does have a higher bond premium, but it comes with a bonus. If your client is able to gain or get full authority from the court, then when they sell the property, you do not have to have court confirmation. All you have to do is send out a notice of proposed action to all of the heirs and or beneficiaries of the estate. And if nobody objects within the limited amount of time that you have to object to a notice of proposed action, then the sale can be conducted privately and without the need of a court confirmation hearing. Now, this is huge because if you're able to do a notice of proposed action, this can save 3 to 4 months or more off of the sales process because of the onerous requirements of a court confirmation hearing. You have to publish in the newspaper prior to the hearing. You're going to have to wait for the order. It's a really long, drawn-out process whenever there's a court confirmation. So whenever you can or wherever you can, if your client can afford to get full authority, it's well worth it in terms of getting your probate property sold quicker. So that's it for today. If you found this video helpful, please give it a like. You can also follow us on YouTube and Instagram at Moten Law Firm. Also follow us on Facebook at Moten & Associates or me, Keith Moten. If you or someone you know has an immediate legal problem that requires immediate attention, contact us at motenlaw.com. Take care and peace.